Hi, my name is Greenberg Hameed.
My name is Pushkar Prihar.
On today's edition of Immigration Insights, we're going to talk about processing delays and strategies that you have available. Pushkar, this is really important. We know IRCC has eliminated 3,000 immigration officers. We know that processing times are greatly exceeding the published numbers, and clients are concerned, and it's having an impact on them. What are some of the options that they can think about when they're in that situation?
One of the remedies available to applicants is that they can approach the court seeking the remedy of mandamus. Mandamus essentially is an order by the federal court to the government forcing them to process a pending immigration application.
And what's the specific test or requirements that you have to meet to know that you might be eligible to use this relief?
So to simplify it, Numan, there's a 5-part test, starting with number 1, which is if your immigration application is delayed beyond the general processing times, which essentially means when the federal government posts the processing time on their website,
right,
if it's gone beyond that.
So you need to snapshot at the time of filing, you need to know what that processing time is, monitor, and if you exceed it, that's the first test.
That's right. The second part of the test is when you or your representative are not responsible for the delay, which essentially means that if the government has made a request to you on your immigration application, you must give them the document that they're asking for. If you delay in providing the document or seek additional time, then that may cause a delay on your part.
Which means it can't be you cannot have contributed to the problem by not responding in a timely fashion.
That's right.
Right? That's the second part. What's the third part of the test?
The third part is that you must represent to the government, you must make a demand. So if you are facing any issue because of the processing delay, you must approach the government and send something we call a demand letter, advising the government of the issues that you and your family are facing, any prejudice that you have, so that the government has an opportunity to then process your application or give a meaningful response as to why the delay has occurred.
Right. Being proactive, putting in writing, making sure they're aware of it.
That's right.
And what are the last two elements of the test?
The fourth part of the test is when the government doesn't give any meaningful response to you. So if you've represented to them, you've sent in a demand letter, but you haven't received anything but automated replies from AI. If that's the process, if the prejudice is so much that you at least expected the government to give you an answer as to why there is a delay or give you a response with a meaningful timeline,
right,
then you can approach the court.
And we've seen a lot of AI-generated responses. We've seen security cases where there's no comment. It just goes into a black box.
That's right.
Right. And what's the last element of this test? I know that there is some question in case law about whether it's, if the significant impact is at a certain threshold. I know there are recent cases around this issue.
That's right. Well, the federal court recently has overturned the previous requirement of significant prejudice. Now there is no requirement of showing to the government or to the court that there is significant prejudice that has been caused to you, as long as there is prejudice, essentially, as an example, to differentiate between significant prejudice and prejudice can be ranging from being separated from your family, unable to kickstart your business in Canada because of the processing delays, and significant prejudice can be filing additional affidavits, clarifying and swearing under oath that these are the issues that you're facing and because of which there are medical issues or your business has suffered a loss of a couple of $1 million.
So as a threshold from the recent court decision is lower, it's not significant prejudice. It means more individuals might be able to access this relief, even if it's not quite at that higher level of threshold.
That's right. What the court has held is as long as the balance of convenience is favoring the applicant, right, you can approach the court and you do not need to prove significant prejudice.
Right. Thank you. I think that's a great review, Pushkar. And for those of you who are watching and are impacted by long processing times, please feel free to reach out and we'd be happy to advise you whether this is a good remedy for you.
Thank you.